Let's roll in business and immigration law updates. This is a presentation of the Khurana Law Firm located in Gaithersburg, Maryland. The chief attorney here and counselor at law is attorney Ramesh Khurana. The moderator here is Kenneth Haber, also an attorney at law who is from Boyd's, Maryland. This attorney on this set questions attorney Khurana on special returning resident visa or SB-1 visa. Let's join these two professionals.
Welcome. My name's Kenneth Haber. I'm a former assistant United States attorney. That's a former prosecutor of the federal government from the Eastern District of Michigan. And I'm also a former senior attorney of the Office of Inspector General of HHS, Health and Human Services. That's the Medicare cops. And with us today is Ramesh Khurana. Welcome, Ramesh.
Thank you.
Ramesh is a world-renowned immigration attorney. I say he's world-renowned because he has clients across the world. And he's located in the DC area, and he helps people with extreme skill. And I know that personally because he's helped me get my wife her green card and get her citizenship, and I wouldn't turn her over to just anyone. It'll have to be somebody that I thought was the best, and that's what he is. And he's here to help us to have a little more information about the SB-1 visa, and this is the capital forum. Ramesh, can you give us a little inside information about the SB-1 visa?
I'll be happy to do that. Before I answer your question, let me thank you from the bottom of my heart for your nice and kind introduction. I really appreciate it.
Well, it's from the bottom of my heart because, like I said, I turned my wife into your hands.
Thank you
so
much.
Her future.
Thank you so much. Now, talking about the SB-1 visa, which is also called the returning resident status. What happens, Ken? If we recall, we had talked about the requirement for a green card holder to stay here in the United States for most of the times, or their intent should be to be the permanent resident of the United States, not staying in their home country once they have become the lawful permanent residents. So, having said that, sometimes people go outside the United States and stay in their home countries for an extended period of time. That's fine, it may happen, but what's the solution? If you are really stayed outside the United States for reasons beyond your control, and you can prove it to the satisfaction of the embassy or the US consulate in your jurisdiction in your home country, then you may be granted an SB-1 visa or returning resident status. This is what it is.
And can you get your green card back if you didn't intend to abandon your residency but you stayed out an extended period of time?
Yeah, Ken, what happens is, let us assume that your green card is still valid. It has not yet expired. It is issued for 10 years in most of the cases, unless it is a conditional green card, in which case it is for 2 years. And if your green card is still valid, so it has not expired, but only thing is you have overstayed. And if you have overstayed, it is deemed that you have abandoned your green card status. Now, you do not want to commit a mistake to come to the US by taking a flight and knocking at the door of the US at Dallas airport. I'm here, and CBP officer asks you a question, sir, where have you been for the last 18 months? And you explain that this was my situation, and CBP officer determines that this long absence from the United States has caused you to abandon your green card, and you are no longer holding your lawful resident permanent status. So that's why if you do not have this status and you do not have any other kind of visa, so you cannot allow to be admitted to the United States. So officer will give you an option. Do you want to withdraw your application for admission? If you say yes, then you will be asked to go back to your country by the next available flight. But if you say no, I have not abandoned my green card status. I wanted to come earlier, but this is something beyond my control. The officer will say, okay, we will issue you what is called the NTA, notice to appear before the immigration judge. Go and fight your case before the immigration court. And if the immigration judge decides in your favor, you get your green card back. Otherwise, you will lose your green card. That's the way it works.
What are some of the winning strategies to get the green card back?
First of all, I would like to advise the audience, if you are intending to stay in your home country and you are a green card holder for an extended period of time, better you apply for the re-entry permit. So re-entry permit basically forgives any long absence from the United States. So that could be a very good situation. Now, number two situation would be, if you have gone there, try to come back as soon as possible, unless it is absolutely beyond your control. Let us say that you have a back pain and you are under the treatment of a physician, and your physician tells you, look, you cannot have a long international flight, you have to be bedridden, otherwise you will damage your backbone. If that is the kind of situation, have the proper medical record, and once you are ready to come back, keep on trying if you can take that flight. So you have to really make sincere efforts to come back to your home, because your home, as per your choice, is the United States. If you still cannot, let's say that 13 months have passed and you are deemed to have abandoned your green card, make an appointment for SB-1, which I answered in response to your first question. Make an appointment for grant of special permanent resident status. The consulate officer is going to look at your situation. The consulate officer is going to interview you, and if they find your statement credible, and if it is a strong evidence that you have been trying to fly back to the United States, but it was absolutely and completely beyond your control, they will grant you SB-1 status. Then you are safe when you come at the port of entry.
Very good. What happens if they were to deny you that SB-1 visa?
Okay.
What will be your options at that point in time?
Sure. I think this is a very good question, because if you cannot demonstrate to the satisfaction of the US consulate that your extended stay was really beyond your control and he denies your application, now you are left with two options. Now, first of all, you can apply for a visitor visa, which is B1, B2, and when you apply your application, you tell the officer, I think I would like to just go and see my family and come back. I do not want to reside permanently in the United States. It will be a big challenge, because before that you applied for SB-1, whereby you try to show your intent that you wanted to come back as soon as possible and you overstayed because of your situation beyond control. Now you are making a statement, I have changed my mind. It may happen, but try to make a persuasive argument. Officer is going to look into your eyes for few seconds and make that decision. If that is not possible, maybe you are the father or spouse of a US citizen, then you have to restart the green card process, which will take about 8 to 10 months.
Restart it from out of the country?
Yes, restart out of the country because you are not here. Then you start from filing I-130 petition.
I think I've heard that one before, the I-130.
Right, right. Like you filed for your wife?
Yes.
Yeah.
Yes, yes. With your guidance.
Yeah, sure.
If a person were to come back into the country on a visitor visa, would he have any opportunity at that point to appear before an immigration judge and make an argument that he really should have been permitted to come back on the original visa, the original green card?
Yeah. So, Ken, basically your question is, let us say a person is holding the green card status. He is coming after an extended stay outside the United States, and when he comes to the airport, CBP officer says no, you stayed really for such a long time and you abandoned your green card, and you go and plead your case before the immigration judge if you don't want to go back. In that kind of situation, yes, you are before the immigration judge, and then you have to convince the court, because ICE, which is the federal agency responsible for removing people from the United States, ICE is going to argue that he already abandoned his home. Especially you are in trouble if you are not leasing a home in your name, or you are not owning a property, you do not have a car in your name, you are not filing your tax returns, and you do not have any health insurance. So, none of the factors which would prove that you had established strong ties to the United States, rather it would indicate that you never intended to reside here permanently. That is why none of these factors is supporting you, then you are in trouble. But nevertheless, consult an experienced immigration lawyer who is going to prepare a good case for you, and he is going to prove, first of all, you never intended to reside outside the United States for more than a few months, and when you left the country, your intent was to come back, and you have entered on an unexpired green card, or an unexpired, maybe, if that is the situation, you were given a re-entry permit, but there are some issues. So, if you prove to the satisfaction of the court that what your intent was at the time of leaving the United States and what is your intent now, and you show your strong family ties, like you have 3 sons, all 3 sons are here in the United States and they are US citizens, and you do not have any 4th child who is living abroad. So, that way you show that your sons, your daughter-in-laws, and
Your grandkids.
your grandkids, all are here, and you are the only one who had gone abroad and got stuck for reasons beyond your control. I am sure immigration court will definitely listen to you, because the point here is, even if you are deported, then immigration court knows it, that you are the father of a US citizen, they will restart the process. Relief is available, immediate relief is available. So, it will be kind of favorable situation.
Very good. Are the immigration judges tolerant of people who have some technical errors, but deep down, have valid cases, but may not have complied with the law in terms of being back, within the time limits, but have their family back here and that sort of thing?
Oh, definitely. Now, as we said, that if a person has strong family ties here, and that person can show, say for example, he would say, I am completely financially dependent on my son, and son was even including his name as dependent on his tax return. There was no need for him to lease a home or own a property because he is financially dependent, and likewise he does not have his own bank statements or bank account because he doesn't need any money. He is financially dependent on his son, and all these factors, along with the fact that all your children are here in the United States and you have decided to spend the rest of your life with your sons and daughter-in-laws and grandkids, why you have to go back? Our cameraman is indicating that we have to wrap up.
Well, I'd really like to thank you again for explaining this area of immigration law. I'm sure it's the type of issue that does come up from time to time, either with people who are viewing us or those that they know, because it's not an uncommon area. Thank you very much.
Thank you, Ken. Appreciate for calling me to your studio. Again, last word to the audience. If you are a green card holder or anybody in your family is a green card holder, please make sure you do not leave the United States for an extended period of time, so that you don't have to face a legally difficult situation while you are coming to this country. Thank you very much for being with us.